Let us discuss the next question. This is from 2019. The ninth schedule was introduced in the Constitution of India during the Prime Ministership of Nehru, Shastri, Indira Gandhi or Morarji Desai. Generally, the questions from this particular chapter, they would be about the provisions which are mentioned in the schedules. But for a change, this question focused on the Prime Minister who was there when the act was introduced or when the schedule was added to the Constitution through amendment. Now in the exam hall, you should think, your first thinking should be, what is there in the ninth schedule? What are the provisions which are there in the ninth schedule? If you recall, certain acts which are protected from the judicial review, the Jamindari Acts and the state regulations with respect to Jamindari, and later on certain acts which are to be protected by the judicial review, all of this were added to ninth schedule so that the protection is provided. And it happened during the very first amendment of the Constitution. Now, if you recall who was the first Prime Minister and when did the first amendment happen, we'll default come to the conclusion that it was during the period of Jawaharlal Nehru. Now let us look at the in-depth explanation. Ninth schedule is in fact added during the first amendment of the Constitution in 1951. And what is the purpose of doing this? In order to protect the laws which are to be protected from the judicial review. And what are all the laws which are tried to be protected under judicial review? Various regulations by the state legislature, especially dealing with the land reforms and the abolition of the Jamindari system. And later on, certain acts of parliament dealing with other matters. And because it is during 1951, the Prime Minister during that time was Jawaharlal Nehru. He was in the office from 1947 to 1964. Hence, the statement is A for this particular question. Let us discuss the next question. This question is from the year 2018. Consider the following statements. Statement 1. The Parliament of India can place a particular law in the 9th schedule of the Constitution. Statement 2. The validity of law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. Which of the following statements are correct? Now, how would you answer this question in the exam? First, you need to think what is mentioned in the provisions of 9th schedule. And if you recall, certain acts which are to be protected from the judicial review are added to the 9th schedule. Generally, the acts of state legislature with respect to abolition of Jamindari system, the land reform acts, all of those are included. It was added during the first amendment act, and there was a repeated question on this in some other year. I think it is in 2019, where the question asked who is the Prime Minister when this 9th schedule was added. So now statement 1 says, Parliament of India can place a particular law in the 9th schedule of the Constitution. Yes, the Parliament has the power to place a law in the 9th schedule of the Constitution. So hence this is correct. Now statement number 2. The validity of law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. This statement clearly says that there can be no judicial review on the 9th schedule acts. Initially, it was so, but later on during the Ayar Coelho judgment, the Supreme Court said that even the acts which are placed under the 9th schedule, they can also be judicially reviewed. Hence, this statement is incorrect. Which of the following statements are correct? It is only statement number 1 which is correct. So answer is A. Now let us look at the in-depth explanation. 9th schedule has certain laws that are to be protected from judicial review, and mostly they have the land reform acts, the abolition of regulations with respect to abolition of the Jamindari system at the state levels, all of this. The powers to place some laws under the 9th schedule stems from Article 31B, which says the validation of certain acts and regulations which are placed in the 9th schedule. Initially, it was that a blanket immunity was given to all these acts and they cannot be questioned in the court of law. But later on in 2007, in the Ayar Coelho case, the Supreme Court said that no blanket immunity should be given from the judicial review for laws which are included even in the 9th schedule. Because in the Keshwananda Bharti case, the court held that you can amend the constitution but only with respect to the basic structure. And in later on judgments, the court held that judicial review is a basic feature, and that is why you cannot give blanket immunity to any law and keep it out of the purview of the courts. but the court put a condition and deadline saying that any laws which are placed after the Keshavananda Bharati judgment, they are open to challenge for the violation of fundamental rights in the 9th schedule. But the laws which are placed before the Keshavananda Bharati case, they will get the immunity from the judicial review. All that is mentioned in the IR Coelho case. So indirectly here, the statement 2 is referring to the IR Coelho case, because it is saying that no law can be questioned by any court and no judgment can be made on it. That is incorrect. If any law which violates the fundamental rights and that law has been made after the Keshavananda Bharati case, they can in fact be questioned and struck down if they are violating the fundamental rights. But the blanket immunity is provided for the acts which are done before the judgment of Keshavananda Bharati case. So hence statement 1 will be correct answer.